over the past year or so, we've been doing something called a death checklist, kind of trying to tick off some of these things that people put off and don't really want to do or may not even know about, that we should all be doing to sort of prepare for the end. And wills is always the biggie. People keep asking, when are you going to do wills? When are you going to do wills? Well, here we are. We're finally doing it. And just like everyone else, I've put it off here until the very end to talk about. So I wanted to touch base with you because you're such an expert in this area. And I think that people, including me, have some difficulty in finding someone who is a voice to be trusted on something like this because you just don't know. And so I wanted to just first, start off very basic here with you and ask you, just from your, experience over the years, who needs a will even? Because I think that pops into some people's heads. Do I need a will? Who needs a will?
Absolutely everybody. Everybody needs a will. People have a lot of misconceptions. They think, oh, I don't have much property, but you still may care who gets your heirloom items, the plates from grandma, the gun from grandpa, the coin, the family pictures, the photograph albums, all of that. So even if your estate is very small, you still care about who gets family heirlooms and other items.
And things can be contested, even pictures. You mentioned pictures. Can that be contested?
Well, sure, people, what if you don't have a will and there's the family portrait on the wall and you got 3 kids? Well, legally, each one would own 1/3 of it. Well, how do you divide it? You can't just, like Solomon, just can't cut the baby. You just can't cut the picture. So what do you do when each person owns a share? Because let's just say a very simple situation. The surviving parent dies and there's 3 kids. Well, each one owns 1/3 of every item, 1/3 of every fork, picture, pair of underwear, pants, couch, TV, whatever. So it can cause huge family problems in trying to figure out who gets what if they're not in agreement. Also, many people die in situations that will give rise to a large estate. For example, a car accident, 50-50 chance it was the other person's fault. Now there could be a survival recovery that would pass. Now it would pass by intestacy or a will. You could win the lottery, you could get a job. You might have minor children and you want to care about who the guardian of the minor children would be. So even for people with small estates, having a will is extremely important.
I think it's also important to tackle some of the terminology in this because, people hear the word probate. They hear some awful things about probate. They don't really know what it means, maybe unless they've been through it or know someone who has. Is that the biggest threat here? That if you don't leave behind something that says, here is what I want to happen to my things, that you have to go through probate? And how hard is that? How bad is that for people who haven't been there?
All right. Well, the first thing we need to do is understand that the word probate refers to 2 different things in the estate planning context. Probate of a will simply means that a court declares the will to be valid. The second definition of probate is the entire process of administering an estate, whether it's without a will intestacy or whether it is with a will after the person dies. Now, the only property that goes through probate, the probate process, meaning property governed by a will or by intestacy, is property that does not get disposed of in some other way. For example, a survivorship right of a bank account or a piece of land, beneficiary designation on life insurance, retirement plan, annuity, 401k, etc. Survivorship rights on a car, a transfer on death provision in a deed. That property is not within the probate realm. Everything else is. A lot of people hear that you want to avoid probate. That very much depends upon which state you live in. In some states, probate is a very expensive, time-consuming, and absolutely horrid process to go through, where the fees can even be based on how much property is in the estate. Texas is way on the other hand. Our probate process are some of the simplest and easiest and most straightforward in the United States. Two things. Our rules for attorneys, we cannot say that probate is an arduous process and that you have to avoid probate. That would violate our ethical rules in Texas, where in other states, that's what you'd have to say. And second, we're a model of other states. I sometimes go and lecture in other states about our probate process, and they think I'm kidding about how easy it is. I say, well, this is what you do. And they say, no, you can't do it that way. I say, yeah, we do it that way all the time. So avoiding probate is not in and of itself something you strive to do. It may be a wise thing to do in your estate for certain assets, but it's not the goal is not to avoid probate. It may be part of a good estate plan.
Thank you. This is really great education here. And I want to ask you we should underline that little portion in there where you said some things are not governed by the will. And we've covered this in one of our other pieces. But if you've named beneficiaries on a life insurance plan, a lot of people do this with a 401k, for instance, when they go in and set this thing up, that's going to trump whatever you write in a will. Is that right?
That is correct. If you have a survivorship right or a beneficiary designation, life insurance, 401k, etc., it doesn't matter what the will says. The will cannot change those designations, believe it or not, except in some situations in only one state, and that's Washington State. There, sometimes a will can trump beneficiary designations, but certainly not here in Texas or in the other states.
So, Professor, you say that absolutely everybody should have a will. We keep seeing these horrible statistics on how many people do not have a will. Why don't people do this? Is it just that they think it's morbid? They think that they've got a lot longer to live? I mean, what keeps people from doing this?
Okay, there are many reasons. Number one is the one we've already talked about. They think they don't have enough property to justify doing a will. And of course, people don't like to think about it. As you're right, it's morbid. You're thinking about being dead. That's the last thing you want to think about. And then you have to think about the death of your partners, your spouse, your kids, your grandkids, your parents. You got to think about what would happen after they die. And that's something that people want to put off. People don't want to spend the time. It takes time to do an estate plan because an estate plan is a lot more than just a will. People have busy lives. They don't want to take the time. They don't want to maybe spend the money that it takes to hire someone to do a proper job. Maybe they have misconceptions. That's a big one. They have misconceptions about what will actually happen to their property after they die. You ask a layperson, if I don't have a will, what happens to my property? They'll say one thing, but reality will be something very different in most cases. And then finally, some people may not want to reveal to anyone, the attorney, the private information they need to do an estate plan. For example, a child born out of wedlock that neither spouse knows about. That can cause a problem.
Let's talk about the money of this. I think that is something that holds a lot of people back. They think, I'm not going to go to a lawyer. I can't afford that. I don't have the money to shell out for this one time to go through and create this document and so forth. If someone falls into that category, what do you say to them? I mean, it seems like there's a lot of other options out there now. There's online. A lot of people have benefits programs at work that include legal benefits, that include, preparing a will. And a lot of those benefits are fairly cheap throughout the whole year. Do you recommend things like that, or is it something where people should be going to an attorney in person?
I would advise against using the online platforms. Yes, the artificial intelligence characteristics, a lot of these online programs are getting much better, but they can't account for everything that an actual attorney looking at your precise situation would do it. As lawyers, we consider people who use the self-help methods to be nothing more than generating more income for us to straighten out the mess they create later on. For people who can't afford it, going to legal clinics, most cities or areas in Texas have some sort of legal aid clinic they could go to. Perhaps you're in one of the larger cities with a law school. They may have a clinic to help you. I love your idea about the benefit programs, because if you have that available to you, Yes, you may not be getting an estate planning expert, but you're going to get someone who knows a lot more than you do about the process of doing it. So, it's like saying you certainly have the ability to remove your own appendix without going to the hospital if you want to, but it's not really a smart idea.
That is a great way of putting it. Okay, that understood. What do you do if you write out a will? I think a lot of people might be surprised to know in this day and age you can still do a handwritten will in Texas. Is that something that you ought to do though? If you absolutely can't afford anybody, you can't find the help, whatever, can you just write it out?
Well, okay. What you're talking about is what we call a holographic will, a will entirely in the person's own handwriting. In about half of the states, including Texas, you don't need a witness, need any witnesses or notarization or any formalities if it's all written in your handwriting. So the answer is yes, you certainly can do it. And perhaps a very simple handwritten document would be better than nothing. I mean, just assume you wanted to write a will and you say, I leave everything to my spouse and sign it, or I leave half to one child, 25% to the other, and 25% to the other, or I leave my car to someone. Yes, that is way better than dying without a will. However, probate judges contact me on a weekly basis showing me handwritten documents that are inconsistent, confusing, and cause all sorts of time and expense. So, yeah, a very simple document might be better than nothing, but it could also cause a lot of problems later on.
Yeah, it seems like that would be much easier for someone to contest, and it might be a lot, it might fall a lot easier once contested. Is that right?
Actually, not.
Oh,
A handwritten
more
will,
education for me.
well,
Yes,
if
this is
well,
great.
by contest, if you're talking about saying the will is invalid, a handwritten will actually has a better chance of standing up because the person actually wrote the whole thing as opposed to just a signature, which could be easier to forge or unduly influence someone into writing. I mean, you could easily, con someone into signing a signature, but hard to make them write a page of will. On the other hand, if you're talking about having interpretation, construction issues, then the handwritten will definitely causes more problems. Not contests, but interpretation, construction, figuring out what actually needs to be done.
And part of what I've heard there, and correct me if I'm wrong, Professor, is if you don't have a will already, you haven't gone and spoken to an attorney, you're about to go, on a, 400-mile bike ride, and you're not very good at riding bikes, it might not be a bad idea to scratch out a will by hand just in the moment in case something terrible happens to you, God forbid, and then do it later with an attorney.
That's correct, because many times a simple, small page will would be way better than dying without one. I mean, uh, so it could cause more problems, but if you don't have a will, that is almost always going to be more difficult. So if you had a one-page will and you just said, I hereby leave all my property to my spouse, if my spouse dies first, evenly to my kids, and I want an independent administration without bond and sign it, that could be way better than dying intestate.
Now, is this one of those things that it's not a good idea though for you to finally go get it done and then set it and forget it, bury it in a safe somewhere, never revisit or revise it again? How often should I be going and looking back at this thing?
I think you should review your total estate plan once a year. Just like you get a medical physical once a year, or at least you should, you need to review it because things change. People are born, people die, people get married, people get divorced. That you'll have a change of feeling towards various people. The laws could change. That could be important. The amount of property you have or what you own could change. So things can change. Maybe you'll look at it and say, oh, yeah, that all still sounds good to me. That's great. But once a year, you should look at it and make sure you still want all those people receiving your property and the other parts of the estate, making your medical decisions and making your property decisions and so on. If you're disabled, all of that should be looked at and reviewed every year.
Is there something that when people do get wills, Professor, is there something that they typically do wrong more than other things that they do wrong? I mean, what comes along more often than not that people get wrong?
Well, doing it themselves, they get a lot of things wrong because they don't know what they're supposed to do. One of the biggest things lay people do wrong is they'll say, I leave my car to this person. Well, they don't realize they may not own that car when they die. They may own a different car, and then the beneficiary wouldn't get that. Or they leave more property than they actually own, like a sum of money. Or they forget to include what we call a residual clause, where everything else goes. So maybe you do give away the car and the house, etc., but you don't give away all the other stuff you may own. And so now you have to have a partially intestate and a partially testate estate. Going to an attorney who knows what they're doing is the best thing. And I do emphasize that know what they're doing. You need to go to a lawyer who has experience in estate planning, someone who is board certified by the Texas Board of Legal Specialization in estate planning and probate, or a member of the American College of Trust and Estate Counsel. That will get you vetted people who have passed exams or have been highly vetted by colleagues, and that gives you a better chance of getting somebody. I have seen way too many attorney drafted wills that had issues in them because the person who drafted it was not an estate planning expert. They're a criminal lawyer, or they do something else and don't realize the intricacies that sometimes are involved with a will.
Let's say that you have talked me into finally, getting off my seat here, talking to an attorney, setting up a will. So I start, the wheels start turning in my head of the things I have and the people that I want to give those things to. Do I also need to have the wheels turning in my head, though, as to who I want to execute all of this in my absence?
Yes. Yes, you do. You need to think about the person you want to be in charge of after you're dead, going to court, doing the court proceedings, gathering all the assets, making sure they are transferred to the right person. And remember, you got to pay your debts. Death is like the final bankruptcy. You got to pay all debts come due. You got to pay them. So you got to have someone to do this. And the person that you want doing is someone who has the correct skill set to do all of those things. What people often forget to do is check with the person first. Don't just name someone without telling them that they're going to have to do it, because being an executor or administrator of an estate is not an honor. It is a burden. It is subject to a lot of emotional hassle and liability exposure. I tell people that if someone asks them to be an executor, their gut reaction should be what I call the cocaine rule, which is just say no. Unless you're doing it out of love and affection and can't get out of it, or you're a professional and it's your job, like a bank, trust department, or a trust company, I wouldn't do it. It's a real hassle, lots of responsibility. So be sure to check with the person first and get someone who's willing to do it and has the skill set and the time to do it right.
Yeah, because they've really got to care about you and the loved ones you leave behind to take on all that responsibility. What a great point, and what a great way to remember it too. How much of a consideration should people put into the idea of inheritance taxes?
Well, unless you're very wealthy, I wouldn't worry about it. Right now, it's about 12 million per person. Even if the sunset occurs and the federal government doesn't renew it, it's still going to be 6 or 7 million a person, I think. So only for the very, very wealthy, who can definitely afford expert tax assistants and attorneys, have to worry about it. Now, what some people do is they hear about other states. There are some states that impose a state estate tax with a very low threshold, meaning an ordinary person with a house and a life insurance policy and a retirement plan may end up triggering a state tax in some states that attacks very middle class type people. We don't have to worry about that here. We have no Texas estate tax whatsoever. It's only the federal, with about a 12 million exclusion per person.
Now, Professor, let's say again here, you've inspired me to go and do a will, and then I hear this word trust, and I think, oh, do I need one of those as well? When does someone need a trust?
A trust is normally used when you do not want to give the beneficiary, the person you're leaving the property to, full control over what they can do with the property. So if you have minor children, a trust would almost be essential, or maybe children under 25 or 30, given that they may not have the maturity or skill set to manage property at the time. Or maybe you have a disabled child, or maybe you have a partner that is not as savvy as they could be. So a trust puts the management of the property in the hands of a trustee, who again should be a skilled, financially savvy person who can then make sure that property is preserved, used for proper purposes, they don't blow it, etc. So minor children, younger adults where you wouldn't want them to have large sums of money, in those situations, a trust is almost an essential part of an estate plan to preserve the money, make sure it's used for education or healthcare or whatever.
I think all of this has been great information, and I wonder, how many things I have missed along the way that you're going, gosh, isn't this guy going to ask about this? What other things would you add to what we've talked about here, Professor?
Well, Jason, you've done a very good job of looking at the property aspects of thinking about death. But people need to realize that unless they are over the age of 60, the odds of dying in the next year are less than the odds of becoming disabled. And therefore, an estate plan needs to consider all sorts of disability planning. If you were unable to manage your finances, you want to name someone in a financial power of attorney to do so. If you can't make your medical decisions, you want to name a medical agent to make medical decisions. Otherwise, these decisions are made by either guardians, which is a arduous, expensive, embarrassing process to be avoided at all costs, that you want to have these disability documents in mind, so you get to pick the exact people who handle it and you give them the instructions that you want. And sadly, you also need to plan for the death event. Do you want to make anatomical gifts? Do you want to be buried or cremated? Or do you have any special instructions? Who do you want to be in charge of those types of things? Do you want what we call a living will or directive to physicians, so that if you're in a terminal condition, unable to communicate, basically you're a vegetable? Do you want the life support removed or not? And the more things you provide for like this, there's also a mental health treatment declaration that you can decide if you have mental health problems. Would you want electroshock therapy? What kind of drugs would you want? And so on. So there's a lot more to doing an estate plan than just dealing with the property with wills and trusts. Jason, you're muted. You're
Sorry.
muted.
Sorry, the music is loud in here, so every time you talk, I turn it down. This might seem overwhelming to people, but once you really give some thought to this stuff, I mean, you obviously don't just run out of the house and go start speaking to an attorney without having an idea of what, you want to do and who you want to leave behind and leave it to and all that. Some of this is just about thinking it through a little bit and then, developing that plan of action. And to be honest, it doesn't really have to take all that long, does it? It sounds like it's a lot, but it doesn't have to take a long time.
That's right. You can do it if you think about it, and you have to think seriously about it. You got to sit down and you have to say, okay, who do I want to get my property? Who do I want to make my financial decisions if I can, my medical decisions? What do I want? Talk with those people that you're going to name to make sure they'll take the job and understand what you want, and then you can go and implement it. So it's just tough to do because you're thinking about things that are very unpleasant, which people like to postpone.
And then they don't want to revisit it again either. And as you said, try to do that once a year. I always like to say, with things like that, put it on a date that you're going to remember, like the week before your birthday. Put it on the date that you're supposed to choose your benefits again at work every year. Put it around that time when you're already dealing with all that muckety muck that you don't want to deal with in the first place. But make sure that you keep revisiting this stuff because, as you say, life changes. Anything else that you'd like to throw in?
I just would like to encourage everybody to do an estate plan. The investment for the benefit it will have for your family will be tremendous, and they will be very appreciative that you have taken all these steps.
If you are just starting out in this process, I think this interview is a great place to begin that. Is there any other resource that you would ever direct people to, whether it be online or whatever? Is there another resource that comes to mind?
There are excellent podcasts and videos on the website of the American College of Trust and Estate Counsel. That's actec.org. And they're made by the top estate planning professionals in the nation. And I think listeners would find those to be both entertaining and informative.
And for everyone on here listening, they know that we don't know what we're doing with this. They're speaking our language. They're not speaking legalese that's, 10,000 feet above us.
That's correct.
Very nice. Professor, thank you so much for taking the time. This is invaluable. I think it really can help a lot of people with something that they need to get done and haven't gotten done.
Well, I'm glad to have talked with you, Jason, and I hope that both you and your listeners find this to be helpful.